dtcc.com. Scroll all the way down and click on Rules and Regulations tab. Then scroll down and click on DTC Rules, Bylaws and Organization Certificate. This will open up the DTC Rules book dated November 2022. Then scroll down to the second page of the index and click on Rule 33, titled Deposit Chills and Global Locks. This rule explains 4 scenarios for when the DTC will impose a chill or global lock over an eligible security. Section 1 states, the corporation shall restrict deposits of an eligible security, a deposit chill, or book entry services with respect to an eligible security, a global lock, when FINRA has issued an order for the halt of trading of the eligible security. B. The U.S. Securities and Exchange Commission has issued an order for the suspension of trading of the eligible security. C. A court of competent jurisdiction orders the corporation to impose a restriction on the eligible security, or D. The corporation identifies or otherwise becomes aware of a need for immediate action to avert an imminent harm, injury or other such material adverse consequence to the corporation or its participants that could arise from further deposits of, or continued book entry services to, the eligible security. Section 1A seems to be the only scenario that is applicable to our MMTLP situation. SEC has not issued any suspension order. No courts have imposed any restrictions. 1D likely does not apply as the DTC chilled or locked MMTLP only after FINRA issued the U3 halt. Therefore, I will focus on 1A, because we have a letter from FINRA halting MMTLP pursuant to Rule 6440A.3. This begs the question, how or when will DTC lift their chill and global lock restrictions? Section 1 goes on to state when the DTC, referred to as the corporation, would or would not impose a global lock, stating, with respect to Sections 1A and 1B of this rule, the corporation shall impose a global lock. Provided, however, that the corporation may decline to impose a global lock if it reasonably determines that imposing the global lock would not further the regulatory purpose of the halt or suspension of trading. For our MMTLP situation, I would argue that DTC has imposed both the chill and global lock restrictions. DTC would likely have to issue a global lock over MMTLP because many investors are outside of North America and across Europe, Middle East and Asia. Section 2 states that the DTC will send a written notice called a restriction notice to the issuer of the eligible security subject to the restriction within 3 business days after imposition of the restriction. This restriction notice states the following 4 things. 1. The basis for the restriction. 2. The date the restriction was imposed. 3. When the issuer may submit a written response to the corporation, setting forth its objection to the restriction and detailing the reasons why the restriction should be released, a restriction response, and 4. That the restriction response must be received by the corporation within 20 business days after the delivery date of the restriction notice, unless the corporation agrees, upon the issuer having established good cause, to extend such date, to constitute an effective challenge to the restriction. Section 2B states that the DTC may respond to the issuer's restriction response by requesting additional information or documentation from the issuer. Section 2C states that the issuer waives its right to make the submission for any deadlines pursuant to Rule 33 by failing to comply with any deadline set forth in Rule 33 or as to any submissions provided, unless the DTC has waived or extended the deadline. Section 2D states that the DTC, the issuer, the issuer's transfer agent, if any and the issuer's authorized representatives, shall use overnight courier and electronic mail or any other method to deliver correspondence to the recipient's last known business address. Section 3 states that the DTC will provide a written decision to each issuer that submits a restriction response within 10 business days after the DTC receives the restriction response. This deadline may be extended for a reasonable period if the DTC has requested additional information or documentation from the issuer or by consent from the issuer's transfer agent or the issuer's authorized representatives, if any. Section 3 has 4 important subsections. Each subsection explains 1. Who will review the restriction decision? 2. How and on what basis the issuer can respond to the restriction decision, and 3. How long the review officer will take to respond. Section 3A states that a review officer of DTC different from the officer that imposed the restriction will make the restriction decision. Section 3B states that the issuer has 10 business days to respond from when it receives the restriction decision to submit their supplemental written response, and that the supplemental written response is limited to establishing that the DTC had made a clerical mistake or mistake arising from an oversight or omission in reviewing the restriction response. Section 3C states that the DTC review officer shall review and provide a written response to the issuer's supplemental written response within 10 business days after the delivery date of the supplement. Section 3D states that the restriction notice, the restriction response, the restriction decision, the supplement decision, and any other related documents submitted will constitute the record for purpose of any appeal to the Commission. Section 4 explains when the DTC would lift the chill and global lock restrictions. Section 4A states, in case a global lock is imposed because of FINRA has issued a halt, and that halt is lifted by FINRA, then the global lock by DTC would be lifted. Section 4B relates to lifting the global lock if the SEC ends up lifting their suspension of trading. In our MMTLP case, the SEC has not imposed any suspension that I know of. Section 4C states that if a court of competent jurisdiction orders the DTC to release the restriction, then it will. This is how the lawsuits that have been initiated are able to get the DTC to lift any restrictions. For example, if Rose's lawsuit orders FINRA to remove the halt, then DTC would subsequently remove their restrictions and it could open for trade. Section 4C and 4D state that if the DTC will lift the restrictions if it determines the restrictions no longer are needed and if they determined a clerical mistake. This chart summarizes my interpretation of the Rule 33, which is broken into 6 steps. First, the DTC issues the restriction notice within 3 days of the restrictions being imposed to the issuer. Second, the issuer has 20 days from receiving the notice to submit a written response to the DTC. Thirdly, once the DTC receives the issuer's response, it will issue a restriction decision within 10 days to each issuer that submitted a response. In the 4th step, the issuers get to submit a supplemental response to the DTC restriction decision on grounds of a clerical mistake or mistake arising from an oversight or omission within 10 days from receiving the decision. In the 5th step, the DTC will issue a decision taking into account the supplemental response will issue the final verdict/decision. In the 6th step, the DTC may release the restrictions if FINRA lifts the halt or a court issues an order directing the release of the restriction. This Rule 33 may or may not apply to our MMTLP situation. I have made a video on this rule with my interpretations and opinions to get investors to talk about Rule 33 and compare it to their own interpretations. Nothing in this video is legal or financial advice, it is all strictly entertainment. Please like, subscribe, follow, and share.